And this case comes before the court today on defendant's motions for summary disposition and a counter motion for summary disposition by the plaintiffs under 2.116 I-5. At this time, I would invite counsel to place your appearances on the record. We can begin with plaintiffs.
Thank you, Your Honor. Ron Vanderveen on behalf of the plaintiffs, Hal Fruit and Peter Steensma, individual plaintiffs, are on with us, as well as Dan Hibma and Terry Lindland, who are owners of the other plaintiff, 3203 PTC. And then we have a few other people who are observers that are potential plaintiffs. We have filed a motion earlier this week, not scheduled for today, obviously, but to add some additional plaintiffs, other owners of condos in the Plaza Tower that are affected by the amphitheater.
All right, very good. Thank you, Mr. Vanderveen. And obviously, that motion isn't before the court today and may be impacted by the outcome of today's hearing, but we'll take that in due course. How about counsel for defendants?
Good morning, Your Honor. Patrick Sweeney, Bloom Sluggett, on behalf of defendant Grand Rapids Kent County Convention Arena Authority.
Very good. Thank you, Mr. Sweeney and Ms. Hartman.
Good morning, Your Honor. Sarah Hartman, Deputy City Attorney for the City of Grand Rapids, appearing on behalf of the city.
Very good. Thank you, Ms. Hartman. Well, Ms. Hartman, I'm going to start with you because I'm not sure that you filed the first motion for summary disposition here, but you filed the thickest one. So it only outweighed, I think, by the plaintiff's response. So I will let you lead off with your motion here. And I see it as, obviously you framed it both as C4 and C8, potentially alternative C10, although as I'm going to discuss later, probably if we get too far into C10 world, it might be premature, but primarily under C4, that is a lack of jurisdiction, and C8, failure to state a claim against the city. So why don't we take those to start out with? First of all, the C4 lack of jurisdiction portion is premised on the idea that this is really an appeal in disguise of the special land use granted, I believe, by the Planning Commission, the Grand Rapids City Grand Rapids Planning Commission, to allow this project to go forward. Why don't you address that first?
Sure, Your Honor, and I can probably be fairly succinct in the overall argument because it kind of touches on both points. The plaintiffs brought their cause of action, including in their amended pleading, as one simply asking for declaratory relief, asking that this court conform their interpretation of what the city's noise control ordinance, as well as the conditions of the special land use approval are. And in that respect, they are in some way asking that this court, one, impose its own opinion on what those terms and conditions or what the ordinance actually says or means, but also to impose its decision on whether or not the city's approval was appropriate. And in that respect, they are asking for this court to hear an untimely appeal. So first, I would argue that the plaintiffs contend that the conditions of the Planning Commission's special land use approval for the amphitheater includes that the sound from the amphitheater would only be 45 decibels or less at Plaza Towers on the other side of 131 from the amphitheater.
Yeah, and I can kind of dispense with at least some of that. I did read through what I can best describe as somewhat lengthy and convoluted, Planning Commission notes. I didn't take your invitation to view the live version of it just because I didn't want to take the time to do that. However, I did read the notations that it's based upon, and there undoubtedly is a notation in there that says, we're going to at least take into consideration going forward all the testimony that was offered today, which would include at least that discussion, I have to agree with you. I don't think it is said as in as many words that we're going to enforce 44 decibels, but we're taking into consideration at least some discussion of some decibel limitation placed on this project. What does that language mean if not 44 decibels? Does it mean anything, or does it just mean uh, we're really not going to do anything about it?
I don't think it's that the city's not gonna do anything about it. I think more importantly, the planning commission resolution does impose clearly that from the June 2023 resolution and decision, that they would the applicant would continue to work with city staff around noise control. And that is what happened over the course of more than the next year. And so you'll see in the 2024, the September 2024 Planning Commission meeting is where they show the additional sound studies that were conducted after additional mitigation measures were undertaken, which still show that it is likely that at Plaza Towers, decibel levels are going to be in excess of 45 dB, which is just kind of par for the course, since 45 dB is more than the ambient noise levels on average for that area. So I think that the conversation, which was Mr. Culhane, who was the architect, not the sound engineer for the applicant, was simply, having a side conversation with Mr. Fruit, one of the plaintiffs, during the planning commission meeting, and it wasn't, specifically addressing the restrictions that were being imposed. And my co-counsel, Mr. Sweeney, can probably address that better, as he, is working with Mr. Culhane and the applicant. But the planning commission certainly took that as just an aside, and that, there would be additional mitigation measures undertaken, which were done through city staff working with the engineer and architect for the project over the course of the next year, following the June 2023 resolution imposing restrictions.
Okay, all right. So I think what I'm hearing you say is, that we're not saying that discussion about sound was meaningless, but rather that it envisioned an ongoing process, and that ongoing process at the end of the day was honored by additional studies, perhaps mitigation measures put into place, and that in effect, at least the city fulfilled what it envisioned doing when it granted the special land use.
Yes.
Okay, all right, and all right. No, I think I understand where that's coming from, and and as I said, after reading that, I certainly couldn't pull out of that. Well, they nailed down the exact parameters of decibels for this project. That didn't happen. And I guess a related question is, and you seem to be aligned with Mr. Sweeney on this idea that they, in subsequent action by the planning commission, or maybe the commission, the city commission, I'm not exactly sure, they amended the noise ordinance in general to permit noise, the additional noise anticipated from the amphitheater project, but that in doing so, they completely knocked out the operation of that city ordinance. I think it's 9.65, that goes into some detail about what decibel levels are at least permissible in special land uses. I didn't see, I did see 966, but 966 says the following uses and activities are not prohibited noises. That would look to me like it refers back to 9.6. I think it's 2 here that Tiger's 3 that talks about 9.63 talks about prohibited noise. And obviously you can't, have an amphitheater that's making prohibited amplified noise going out into the city. That would never work. So it makes sense to exempt the amphitheater, but I don't see anything in 9.66 that exempts the amphitheater from the requirements in 9.65. Can you explain or you give me your perspective on that?
Sure. I think that when you look at that in context with the legislative history, which is the resolution that I provided in attachment to the briefing, the clear intention of the city commission when it modified its noise control ordinance to include that all sound and vibrations produced by the amphitheater between 7 a.m. and 11 p.m. would be exempt, except as provided in subsection 7, which is after 11 p.m. and only when there is prior written approval from the city manager or his designee.
Can you direct me to which of your exhibits contains that legislative history, as it were?
Hold on. It is Exhibit D, Noise Ordinance Section 9.66, which includes the resolution authorizing the publication and setting the date to consider the ordinance changed to nuisances.
All right. Let me take the okay, I think I'm close here. C, D, there we go. Okay, I got it. Okay, and that's in effect the legislative history. What you're telling me for 9.66 contains
Yes.
my answer in that you're saying that legislative history. Now, does that mean, and I think that this is, sort of a commonsensical point put forth by plaintiffs in this matter. It can't mean that the arena can make whatever noise it wants and that, someday a group might say, well, we'd like to do one of these directional sound weapons like the military uses because that's part of our entertainment. We're going to aim it straight at the Plaza Towers and there just simply is no limit as long as they're between the hours. Is that what I'm supposed to read it like?
The ordinance says that, but the amphitheater is still governed by the special land use conditions, which aren't carte blanche to make whatever noise is possible. The planning commission still has in effect the conditions that were approved by resolution and as amended after the parties continued to work together to have additional sound mitigation efforts in place as proposed in the 30, 60, 90 different design dynamics that were put forward. So the planning commission certainly would continue to say that there are some limitations on sound coming from the amphitheater, and it would enforce the conditions of the special land use authorization, just that 45 dB at Plaza Towers is not one of those conditions.
Okay, and if I, rule today and declare that, well, it looks like that, however, 6.5 remains in there, that sets a different and higher, and it seems to me like none of the proofs I've seen thus far establish that different and higher decibel level has been exceeded. And again, I was a little unclear that 9.65 was not crystal clear to me in terms of where it would be measured from, but I don't think anyone's advanced, per se proof as of this hearing, and Mr. Vanderveen may set me straight on this when it's his turn, but that there is a certainty that that's been exceeded at the decibel levels in 9.65. If I do declare that 9.65 remains in effect, where does that leave us, in terms of particularly regarding the city's role in this whole thing?
Well, first, the city would probably go back and amend 9.65 to then make sure that 9.66 applies to that.
Sure, you might have mind
provision as
9.66,
well.
I suppose, to
Um,
say, by the way, we mean not 9.65 either. I get that. Okay.
But also that as far as actual violation of 9.65, this is not an actual, the case that's been presented thus far is simple declaration that we're in. That's not what the plaintiffs have asked for or pled.
Well, I think their count two asks for a declaratory judgment that, hey, judge, even if you don't find the 44 decibel limit like we want, that the noise limits in 9.65 are enforceable. I think that's a portion of what they're asking for, though not everything they're asking for.
Yes, but they have not asked for or alleged that it's actually being violated. Just
Right,
that any
yeah,
future
there's not a
violation
proof.
would constitute, yeah.
Yeah, I agree, right, that, although again, I'm gonna give Mr. Vanderveen a fair chance to weigh in on that. Well, and I guess then that brings me to, kind of the C8 portion of your motion in that, if I make that declaration, the city can do what, of course, it wants with it. But I find that, there's still discovery remaining, therefore, on whether or not a nuisance per se or a nuisance in fact is occurring under, and again, I wouldn't probably go so far as to say, well, if it violates that, it's going to be a nuisance per se, and decide the whole case. In effect, as we sit here today, there's probably some additional discovery to be done. Should the city remain a party to that, or is the city's role done and over with because of the, sale of the amphitheater to the CAA?
Well, my position would be that the city would be done with it, at the point where neither of those apply.
And you also might, I mean, obviously the city may still have, because I think there was still some envisioning in there of an enforcement role for the city in the Environmental Services Department, but not necessarily as a party. After all, you're not making the noise. All you did was set the rules and set the parameters, and it's now in the CAA's court in terms of what actually happens at the amphitheater. Is that accurate?
That is accurate. I would also say that the case is only pled as a nuisance per se, not as a nuisance in fact case.
Okay, all right. Well, and I'll take that up with Mr. Vanderveen. I did see at least someone referencing nuisance in fact in there, and right, and you're saying those are totally separate and distinct. It's not a account for nuisance; it's account for nuisance per se. Or and I'm here. Gosh, my much more common in front of me would be negligence. And of course, there is negligence per se, in some instances. And then there's just straight negligence, which is usually a question of reasonableness in conduct or behavior. You're saying those are distinct causes of action.
They are, Your Honor.
Okay. All right. Well, and you may very well know better than I do. So, all right. Well, let me go to Mr. Sweeney.
Thank you.
Sure, Your Honor. I'll try to build on what Sister Counsel talked about. So, would you like me to address the sound ordinance or the planning commission approval first?
Why don't we go straight to that sound ordinance? Because I really think, as I read through this last night and I read that statutory language, and of course I haven't spent nearly as much time with it as any of the attorneys involved with this case, but it occurred to me that 9.66 doesn't look to me like it is as, that it's just simply not clear enough that it excises 9.65 totally out of consideration for the purpose of the amphitheater. I can see, a statutory scheme where you say, well, we're going to allow this thing to make noise and during certain hours, but we're going to frame those, and here's our existing framework, and that's in 9.65. And I also, just in reading through all of the language about the discussion of the special land use, it seems to me that that's not inconsistent with what was said during that hearing, because I don't think anyone was saying we're going to let them make as loud a noise for as long as I mean, they always envisioned that there would be parameters. There was some discussion of, boy, it's a lot easier to put a time parameter around a thing like this than a decibel parameter because of the difficulty of measuring decibels at different locations. But, there was a lot of discussion about decibels as well. Some of it from Mr. Fruit, some of it from Mr. Culnane, and some of it, being in the resolution itself, which says, hey, we're going to have this ongoing discussion about sound, and referencing the rest of the preceding discussion, that inevitably talks about decibels. So I don't think it necessarily excludes, the existing framework under 9.65. So what's your thought, your argument regarding that?
Well, sure, and the court referenced the planning commission, so I'll turn your attention to page 18 of that planning commission meeting, where they're specifically talking about the sound ordinance, right? So there's discussion here from Ms. Turkelson. It is acknowledged at this point that the sound ordinance would not support an amphitheater use, and that it would be far more limiting and wouldn't be a tool they, being the city, could use for enforcement because of the nature of this use and the regulatory structure of the current noise ordinance. So that's the point where they're setting up to say, you know, we're going to have to do something with the noise ordinance. We're going to change something because, and I would posit this is a direct reference to section 9.65, the sound pressure limitations that are going by decibel, because even back in 2023, it is acknowledged by everyone that the amphitheater cannot operate within those sound pressure limitations.
Sure. Well, and it also can operate within the prohibited noise limitations because, for example, if I tried to, well, I'm not a good example because I'm in East Grand Rapids here, obviously very limited confines. My neighbor Niall Deems had a band a few years ago, and I didn't grieve him over the sound ordinance. I think it was some kind of fundraiser that he did. But let's go back to the city of GR. Looking at the sound ordinance, I mean, it wouldn't, the amphitheater wouldn't be permitted under the prohibited portion, you know, of the statute either, right? I mean, it just would never fit under.
Right, and in their response, the plaintiffs argued that, well, okay, the amphitheater would be a prohibited noise under, I believe they referenced 9.634, which is operating amplified sound louder, that basically you can hear louder than a conversation.
Sure.
And that would, you know, I would say that would cover your neighbor's performance.
A better example would be if I hired a band at the next courthouse event, and we put them out in front of the courthouse and we blasted that out at you know, whatever level of decibels you know, we would want. Doubtless my colleagues and I would want a heavy metal band out there, and we were shaking the adjoining buildings and the defender's office and the city offices and all that stuff. We'd be in violation of that 9.63. We can't do that.
Well, right, and let's take a step back from beyond the context of playing music, right? I mean, go to a high school football game. They have loudspeakers, they have announcers. Those are sound amplification devices. I mean, that would presumably also fall. I mean, there are a lot of specifically sound producing items that would fall within either the category of a just purely prohibited noise, or of course would then exceed the sound pressure limitations in 9.65. Now, so again, if the argument was that this amphitheater would qualify as a prohibited noise, which, as the court has noted, it doesn't seem to call out some use like this. But even if it were, that would mean that it would be subject to a restriction that you would not be allowed to hear it 100 feet away as louder than a conversation.
That's under 965 or 963?
That's 963.
Yeah, 963 is very limiting, right?
So there's no venue in the world that could satisfy that sort of requirement. Now,
well, maybe the harp in the you know, I was just up at the Grand Hotel for the judges conference, and they have a harp in the lobby. That might I don't know if I could hear that 100 feet away, but yeah, except for that harp, I'm guessing you're right. Not too much is going to go shorter than 100 feet. So
right. So, and then you have 9.66, which again, the court has to read all of these ordinances together. Right? That's a fundamental principle of statutory construction. So how do you harmonize these ordinances, which I think, as the plaintiffs have pointed out, maybe they could have been drafted a little bit clearer. But I don't think you have to read anything extra into the ordinances to understand what they're saying, because you go to 9.66 and the discussion from the plaintiff's perspective has been, okay, we're looking at subsection 6 and 7, right? Because these are the ones that apply to the amphitheater. And I would also just call out the fact that this is not a complete exemption from the sound pressure limitations, as has been suggested. It is a partial exemption for 7 a.m. to 11 p.m. So otherwise, we're all in agreement that those sound pressure limitations, decibel limitations in 9.65 do apply to the amphitheater. They just apply outside of that exempt period, right? So let's look further at the other sorts of sounds that are exempted under 9.66. Lawnmowers, snow blowers, emergency vehicles, the loudspeakers at sporting events. I mean, all of these uses categorically they're not necessarily prohibited, right? You're not going to find all of that stuff in 9.63, but all of these are things that categorically would violate the sound pressure limitations in 9.65. So as we said in our reply, if the plaintiff's argument is taken as correct, then you have to apply it to all of the exemptions in 9.66, which would mean that if you're running a snowblower, if you have a loudspeaker at a high school football game, if an ambulance turns on its siren in the city limits, they all have to comply with the sound pressure limitations, and they can't. They're significantly louder than that. So if the court were to interpret the sound ordinance in the way that the plaintiffs are suggesting, it's not just going to impact the amphitheater. It impacts every single exemption listed under 9.66. And you would be declaring all of those things also subject to a sound pressure ordinance that they cannot comply with. I mean, you can't have a siren that provides the necessary safety requirements of alerting people you've got a high-speed vehicle coming if it has to be less than 75 decibels. So the issue is much broader here than just this amphitheater question. And the court has to look at the entire operation of the sound ordinance to understand what it means, because prohibited noise, which is the statutory, the ordinance term that the plaintiffs are latching onto, that's not defined anywhere in the ordinance. So the court has to look at the context of the entire ordinance to understand what that term means.
Okay, in that you're saying that 965's function is narrower than I have posited here, in that what it does is it sets some parameters above which anything would be a prohibited noise, but that the idea of a prohibited noise knocks it completely out of play for those 7 listed exceptions under 6.6.
Exactly. You've hit the nail on the head that if something is a prohibited noise under section 9.63, we don't even have to look at 9.65 sound pressure limitations. So
right.
Again, if the plaintiffs are correct, and we take into consideration the fact that this prohibited noise exemption is limited temporally, you end up in this bizarre situation where during the operational hours, they would be subjected to the sound pressure decibel limitations, but outside of the hours, now it's just prohibited completely.
Okay, yeah, and I again, the that 6.5 is not so clearly written that I'm able to, interpret whether or not it's repetitive type noises, or whether it's a constant noise. That seems to be a one differentiation it does make, and of course it also contains some different limitations based on the time, but it's less than crystal clear to me. All right, well then I guess that brings me to the same question, that if I rule today that 6.6 only knocks out 6.3, with regard to the arena authority, and still 6.5 remains as the reference point, the statutory reference point, and thus we need to proceed forward. Do you agree, first of all, with the city that it's pled as a nuisance per se, and that it has to proceed only under that rubric, or can I look at the nuisance in fact framework as well?
Well, that's been our position all along, is that this should be a nuisance in fact case, right? But the plaintiffs have intentionally not pleaded a nuisance in fact claim. Our presumption is it's because they don't want to have to actually introduce the proofs to establish a nuisance in fact. Now, if this were to proceed as a nuisance per se claim, there still would have to be some kind of an amendment, because again, that claim is not pleaded. So if this case is to move forward toward any kind of relief with respect to the amphitheater, it can't do so under these pleadings, because they've only asked for declaratory rulings interpreting the planning commission approval and the sound ordinance. Now, with respect to the nuisance per se claim, that fails regardless of whether you rule that the sound pressure limitations in 9.65 apply, because you can't have a nuisance per se based on a nuisance ordinance. That was laid out in Township of Ypsilanti versus Kirchner, I believe was the citation. Yeah, Township of Ypsilanti versus Kirchner, 281 Nishap at 278. There, that was a nuisance abatement action, and the township had declared this particular property a nuisance per se under its ordinances. And the Court of Appeal says, whoa, no, no, no. The mere violation of an ordinance is not a nuisance per se. You have to have statutory authorization to declare it a nuisance per se, like in the zoning enabling. But we're not talking about a zoning statute, we're talking about a noise ordinance. And so the legislature has to pass a law that says, okay, municipality, you can declare a violation of a noise ordinance a nuisance per se. That doesn't exist here. So if the court were to determine that 9.65, the sound pressure limitations, apply to the amphitheater, and the city doesn't change its ordinances to accommodate that, it still would not constitute a nuisance per se. At most, it would constitute a public nuisance, which still has to be proven factually.
And there's where we get to the, well, I mean, both public nuisance or nuisance in fact and nuisance per se contain some discussion of what a reasonable person under similar circumstances would find tolerable. That's where we get to that kind of classic.
The distinction between a public nuisance and a private nuisance, those are both nuisance in fact claims. A public nuisance is something that is just enforceable by the municipality because it affects the public at large. But both of those nuisances, public and private, you have to actually prove that the use is unreasonable.
Okay, and what I hear your argument here is that that's not what's pled, and that's what ought to be pled, Judge, even if this case goes forward with the CAA as a defendant, because I'm holding the that you know, there's nothing in there that knocks 6.5 out of existence.
Yes, if the court were to hold that way, then there would have to be some kind of a claim advanced against the CAA that the sound being produced at the amphitheater constitutes a nuisance in fact, that it is actually unreasonable and harmful to neighboring property owners.
And the per se is out, even if they have already exceeded that, even if they stepped in here tomorrow and said, Judge, here is our proofs. This is going to be per se because there's no enabling statute out there that allows enforcement of that. Does that have to be a state? You referenced the legislature. Can the city enable it as well?
No.
Okay, has to be a state law in effect enabling that, and that simply just doesn't exist.
Right. For then that's specifically for if you're alleging that the violation is of an ordinance, and that creates a nuisance. That could be a public nuisance, but it can't be a nuisance per se unless the authorizing legislation allows it. Because remember, all municipal power comes through authorization from the legislature. And that's specifically why violations of zoning ordinance can be nuisances per se, because there is a section of the Zoning Enabling Act, which establishes zoning authority, and it says a violation of ordinances under this act are a nuisance per se.
Okay, but that of course is not the sound ordinance isn't a zoning ordinance, it's a separate animal.
Right. The sound ordinance is part of the city's nuisance ordinances, which is exactly the same kind of ordinances that were at issue in Kircher. And that's where the court said, look, you have to actually provide a hearing and you have to prove that the operation of this property is a public nuisance. You can't just declare it a nuisance per se because it's violated a nuisance ordinance.
Okay, all right, and like Ms. Hartman said, you think pleading nuisance per se versus public nuisance, that it's not enough to just say the word nuisance, you've got to commit to one or the other.
Well, I don't think the public distinction really is at issue here, right? Because public and private are just two different kinds of nuisances, in fact. What I'm saying is they haven't pleaded a nuisance in fact claim.
Okay, yeah, which is distinct from
which is distinct from a nuisance per se.
Got it.
Because a nuisance per se claim leapfrogs the factual proofs of reasonableness.
Got it. Okay. Well, let me, anything else you'd like to add, Mr. Sweeney?
Sure. With respect to the approval, I agree with everything that Ms. Hartman said. This is, if the court read through the Planning Commission meeting minutes, there are lots of different discussions about sounding, right? And the main reference is to the reports and estimates provided by the developer. And then, of course, we have a subsequent meeting, we have subsequent developments. We have this report that comes out that projects sound amplification around Plaza Tower to be, I think it was in the 60s, 70 decibel. So again, the city commission, they move forward with the approval, knowing that they're actually getting some hard data that's showing sound is going to be louder than 45 decibels at Plaza Tower. And you look at Mr. Culhane's comments, and he's saying, well, yeah, there's a bunch of buildings out there, half a mile to a mile away. The sound is going to dissipate eventually down to 45 decibels or less. Now, Plaza Tower is about a quarter mile from the amphitheater.
Yeah, pretty much the closest building line of sight from dead center of the amphitheater stage is, I think plaintiffs pointed out in their brief.
Right. It might be a different situation if Mr. Culhane had got in front of the Planning Commission and said, all right, Mr. Fruit, he lives at Plaza Tower. He's worried about the sound. It is not going to exceed 45 decibels at Plaza Tower at Mr. Fruit's condo. He doesn't come anywhere close to saying.
Yeah, he was circumspect about it because he was considering Bridgewater Place and some other, residential places that are further away and, perhaps have more stuff. And maybe part of that sound gets absorbed by Plaza Towers. I'm not exactly sure. So, right, he was making that, I think legitimate point that it's going to be different depending on the distance and the mass that occurs between you and the amphitheater itself and the building that takes the first wave of sound, as it were. So
exactly. And I'd remind the court that the city is under some restrictions here too, right? This is a licensing permitting decision. You have to speak with some level of clarity if you're imposing a condition on a license. So the city incorporated generally all of the communications that took place during that meeting. And they weren't just talking about sound. I mean, they're talking about parking, accessibility,
traffic,
design, public utilities. And so the city put a condition in there that says, look, we're expecting that this property is going to operate generally as has been presented to us. If they wanted to impose a strict decibel limitation on a specific property, they have to say more than that. If that was truly the condition they wanted to impose on us, we challenge it as being unconstitutionally vague. The law requires a little bit more of a governmental body if it's telling a landowner conditions of how to use its property. So there's no reasonable way to interpret that catch-all provision as referencing a specific decibel limitation at a specific piece of property.
Okay. All right. No, I think I understand what you're saying, and I agree. Mr. Klein was circumspect in his remarks throughout the hearing enough that he didn't necessarily commit himself to any. He was, making some what I want to refer to as educated guesses on what decibel levels might be. But it was also early in the process, and that the ultimate resolution envisions this ongoing process where sound and there are further sound studies which it looks like are done, and they contradict what the architect said at the first one, and said, what, we could get up to and some scientific thought 66 or 68 decibels at the riverfront towers, given the lay of the land, and this much more scientific sound study that was done. So okay, all right, well, let me Mr. Vanderveen's been waiting very patiently in the wings, so let me hear from him.
One thing that's tough about being on the non-moving side here is that
You gotta absorb all that stuff.
you have to wait and listen to all that stuff and be quiet for a while.
You've done admirably, Mr. Vanderveen. So now's your turn.
Thank you. Thank you.
And I think you can tell, kind of where I have, to come down after spending hours and hours learning. I wish I'd listened in physics as to what a decibel was, back when I took it in high school last. But if I learned it once, I've now forgotten it. So.
Yeah. Well, I appreciate what the court has said about the Planning Commission's special land use approval, but I want to just address that a little bit first here. I don't want to give up on that issue, because I think if the court thinks it through, the court will understand that there is a limitation. First off, we start off with the fact that the zoning ordinance, section 50912 and section 50912 and 5129
Are those attached? Are those part of your exhibits?
Yes, they are, Your Honor.
Which one? So you can, I think I'm close here.
51209 is exhibit 12.
Okay, yep.
5912, sort of a tongue twister because the numbers happen to be reversed. But 5912 is exhibit 13. So
Okay.
exhibit 13 is on live entertainment. And it says when the Planning Commission is to decide a special land use for a live entertainment facility, that they need to consider the things in the noise ordinance and the noise imposed on neighboring properties. Exhibit 12 is the zoning ordinance section on special land uses that also requires the Planning Commission to consider the noise to be imposed on other neighboring projects or neighboring properties. And so that is one of the requirements that they have to take into account and decide on. Now, they didn't make a decision on noise at the June of 2023 hearing unless that noise is based on Mr. Culhane's testimony. Mr. Culhane is not a guy off the street. Mr. Culhane is a professional engineer hired by the developer to come in and make a presentation.
Architect. I thought he was a progressive. So I in my head he was an architect, but am I wrong on that?
Well, I think they refer to him as an executive engineer.
Okay.
But in any event, he's the professional that comes in to make the presentation to the Planning Commission. And he makes the presentation. Mr. Hal Fruit, again, his name is spelt wrong in the minutes, but Hal Fruit raises the question about Plaza Towers and other buildings. He didn't say some buildings, he said Plaza Tower and named other buildings. And Mr. Culhane answers about the buildings referred to by Mr. Fruit, and says less than 45 decibels. Now, that's the only thing in the record about sound in that Planning Commission meeting. In terms of the adjacent buildings, they talk about higher levels in the amphitheater, but it's the only thing relating to the adjacent buildings of Plaza Tower. and they adopt their approval of the conditions with operation per the testimony. Okay, so that's what happened there. They never did make another decision when they came to the site plan. First off, they were told by the city, don't consider noise. And then they adopt the same conditions that the special land use had. So they just carried that forward. There's
Right.
never, counsel for the city indicates that the planning commission has worked on this going forward. They have not. There are no minutes to show that the planning commission ever made any approval of any noise study or any noise limitations. The argument is that there are no limitations.
What about those very colorful overlays that are included? I think your exhibit 19 here.
Mhm.
Yeah, acoustical predictions, a 90% design review and final report. Isn't that all about noise?
It's about noise, but if you look at the date on there, that's the date in 2025. The last planning commission action on this was in 2024. They never reviewed this. They never approved this.
I see. So I mean, this what got done, but if at best at 2024 it was a work in progress, it was not presented and complete at that point.
Yeah, and the planning commission has never gone back and said, well, we're changing our conditions, we're imposing any conditions. If the city's argument and the arena authority's argument is correct, the planning commission totally abdicated its role in the special land use approval. I don't think they did. I think they listened to the testimony. They heard Mr. Culhane, who Mr. Culhane is the one that gave most of the testimony. He says less than 45 is going to be attenuated down to less than 45 at these buildings. Okay, so the planning commission acted on that. The neighbors didn't appeal because the neighbors heard that.
Yeah, they thought they could live with 45. It sounded like, well, that would be okay if that
Sure.
had worked out. Well, because after all, I mean, and I guess, part of the argument here is, look, Judge, 44, 45 is the ambient noise at the amphitheater, with nothing going on, with just street noise going on there, or outside the Plaza Towers. That could never be a reasonable limitation. How do you address that?
Well, it is a reasonable limitation. If you have two noise sources that are 45 decibels or less, that's 45 decibels or less. And so, it's not that you add them up. Two sources that are 45 don't equal 90. Two sources that are 45 are 45. And that's why they could live with that. And that's why they didn't challenge and don't challenge that determination by the planning commission. And so, we would submit that is what the planning commission did. And these arguments today about, oh, the planning commission thought this, the planning commission thought that. It's not in their minutes. They act through their minutes. They make their decision through their minutes. And their decision includes reference to the testimony before the planning commission. They didn't have to put Mr. Culhane's testimony in that about the 45 decibels in the minutes if they didn't think it was important. They had the sole choice of including that, and they chose to include that in the minutes. So I think that when they adopt conditions that are subject to the testimony before the planning commission, then that's what the condition is. There is no other evidence submitted to the planning commission for that special land use approval that addresses sound at Plaza Tower. That's the only thing. And it comes from the hired representative, professional representative, Mr. Culhane, of the developer in the city. Anyway, so that's our position on the special land use approval. The minutes adopt that condition. Now, trying to say that this was some side conversation, comments made to the planning commission are addressed to the planning commission. They're not discussions by people in the audience. And they're included in those minutes, as I said, because the planning commission determined that they're important to include. Going on to the noise ordinance, I think the court has it right on track that the section 965 of the ordinance, the noise ordinance, is not made exempt by 9.66. Prohibited noises are defined in the ordinance code. Prohibited noises are defined in section 9.63. 9.66 merely removes the amphitheater up until 11 o'clock from the prohibited noises. And 9.65 talks about the sound level limitations of non-prohibited noises, and they're not excluded. And the amphitheater is not excluded from that in 9.66. Now, council would say, that means all these other noises are per se illegal. Well, we don't know what a snowblower is in terms of volume, or we don't know what a speaker is at an athletic event in
Sure, what about an
volume.
ambulance? I mean, that's the thing that hurts my ears when it goes by in the parade and they
Sure,
hit the ambulance or emergency vehicle. Those would seem like those would always be prohibited if we have to live with 965.
not true. And I'll tell you why. 9.65, and it's a subparagraph 3 that applies, talks about the limitations of sound for use of property. An ambulance driving down the street is not a use of property. A police car driving down the street is not a use of property. The amphitheater having concerts on the property there, that is a use of property. And that's to what it applies. It applies to a factory. It applies to other things that are uses of property. And so that part is not a problem. Now, counsel for the city also indicates that the legislative history of the noise, the amendment to 9.66 refers to exempting them from the noise control ordinance. That's not legislative history. That's a memo from a staff person at the city. And the city commission voted on the exact wording presented to them by 9.66, which is only exempting it from the prohibited noise category. You can't have a memo to the city council, city commission say, hey, the grass outside city council is orange, and adopt an ordinance. First off, there's no grass there. And then secondly, it wouldn't be orange anyway. So regardless of that, if you adopt an ordinance that says one thing and you have a memo from some staff person that says something else, the ordinance language governs as a matter of law. And the court has right on track the fact that 965 still applies to the city. Now, council said that you can't have a nuisance per se based on noise. I don't think that's accurate. First off, I don't think that's accurate from the Ypsilanti case. The standard is a thing that's prohibited by law, but we can go beyond that, and you don't have to rely on that. Our Exhibit 13, Section 5.9.12, and paragraph C says, that's the zoning ordinance now, that says that building a live entertainment facility, and that's what the amphitheater obviously is, a live entertainment facility has to comply with the noise ordinance. So violation of the zoning order of the noise ordinance is a violation of that section of the zoning ordinance. Again, everybody seems to agree that a violation of the zoning ordinance is a nuisance per se. And that's because it's said in the statute, it's said in the ordinance code, that the violation of the zoning ordinance or regulations is a nuisance per se. So here we have the noise issue is a nuisance per se. Now, if the court wants us to amend the complaint to refer to a nuisance in fact, certainly that can be done. But we would submit that our request is for the court to determine the standards. The standards as they stand today are 9.65 applies and applies through the zoning ordinance, and the Planning Commission's decision on the special land use approval, which has never been changed, applies to the amphitheater, adopting the testimony as the standard that they were obligated to consider. The noise levels they were obligated to consider. The only consideration is what Mr. Culhane said. And so we would submit that the court should deny the motions for summary disposition by the defendants, and the court should grant our counter motion because the interpretation of the Planning Commission minutes and the interpretation of the ordinance is simply a matter of law. No testimony in the world is going to change what's written in the law.
Okay, no, right, agree that, at least, this is my first time, I think, encountering, at least the planning commissions, their, looks like here what they call it here, resolution, and, it's unique incorporation of the, um, discussion before that, which, of course, any drafter is going to tell you is a recipe for ambiguity, because the discussion is just that. And I guess, as a preliminary, I'll state the, basic facts that I'm operating on here, and then my conclusions of law, so we can move this thing along in at least a, somewhat coherent manner today. So the planning for this amphitheater began, of course, years ago. Various designs were proposed. The city was heavily engaged, and also engaged at some point the Convention Arena Authority to plan and create a site plan for approval by the city to create a new amphitheater in the downtown area of Grand Rapids. And pursuant to that, some changes had to be made, both by the Planning Commission, primarily by the Planning Commission. Here is, I believe, the Planning Commission. Take a look here. Actually, and the full City Commission, I guess, with regard to the actual noise control ordinance of the city of Grand Rapids. And the reason that those special land use was required was quite straightforward, in that this was going to be a new entertainment venue. It was going to feature different music acts. And I will note that, this wasn't a situation where the amphitheater was built for the Grand Rapids Symphony or, the classical music organizations, or, the local church choirs, or anyone else. It was an amphitheater built to, presumably, in fact, host national acts that might be touring and inclined to stop in Grand Rapids and play a suitable amphitheater as their schedule permitted. And logically, that would incorporate anything from the soft strumming acoustic guitar of some musicians to the hard driving rock and roll, doubtless Five Finger Death Punch and other acts that I've noted booked there are going to be much louder in the music that they create. So in doing that process, there was a special land use ultimately required for the moving forward of the amphitheater project, and that was addressed, before the court. This is exhibit number 8 to plaintiff's brief, their motion for summary disposition brief that I'm referring to. All of the parties have, however, referred to it, and it is. These are minutes, and they are minutes of June 22nd, 2023, of the City Planning Commission meeting. And the minutes, as I've pointed out, are they read like minutes. They don't read like an ordinance or a resolution. The portion that reads like a resolution is the end of the document here. And I guess I'm at this same document beginning on page 23, where the Planning Commission ultimately does resolve and approve the special land use request. Now, notably, that approval itself, which is printed in bold, and if anything can be said here as to be the certainty that this is what the Planning Commission intended to do and implement in terms of its uh, rulemaking going forward. This would look like that to the court. And paragraph 5 there says that the proposed use will not be detrimental or disturbing to existing or future uses or to the public welfare by reason of excessive traffic, noise, smoke, odors, glare, visual clutter, because pursuant to the submitted noise study, the freeway will act as a noise buffer for areas north of the project, and the bulk of the noise generated by the venue will be directed upwards by the lawn seating berm and dissipate over the river. Most attendees, and talks a little bit about lighting and transportation there. So there is some discussion about how the noise is going to be dealt with, and that this is at least a concern of the Planning Commission during that. And they further address that, and they say here on page 25, the following conditions of approval shall apply to this project. One, standard condition set A, approvals, and there it says Romanet 2, that the you shall operate according to the application and per testimony as recorded in the Planning Commission minutes. Well, that does incorporate all of this testimony and statements that are made part of the minutes going forward. And then finally, the paragraph 6 of the actual resolution states that the applicant shall continue to work with the city to evaluate potential sound/noise resulting from the use and implement any necessary mitigation measures through final site and architectural design to the extent necessary. There's been various testimony that has continued, and in fact, the ongoing resolution of the Planning Commission did envision that. And it's also envisioned through here, during these same notes, the Ms. Turkelson, on behalf of the city, does indicate that, and here I'm on packet page 19, it is, or actually packet page 19, but it's page 17 at the top of the document of that June 23rd, 2023 meeting. Ms. Turkelson said, though, it's part of the application and testimony for this project that there's a baseline expectation. Now, notably there, she's talking about Mr. Culhane's discussion of rock and roll music. The loudest of all music is typically at that decibel level. That is 105 decibels that's being chosen as the baseline for a sound analysis. Now, it appears that sound analysis has not been fully completed yet, and that because Mr. Culhane states earlier in his testimony that he wasn't able to produce the diagram, and apologizes, I believe, to Mr. Fruit because he had indicated perhaps that he would create a diagram indicating how that sound would radiate out from the amphitheater, and it simply wasn't produced there. Now, Ms. Turkelson then says, therefore, that would be one of the enforcement components that should there be an issue needing to be investigated, indicating that there is. And then the next page, on page 18, Mr. Culhane replied that the modeling currently doesn't include that. That is something they would add to mitigate and modify the sound, i.e. indicating that the sound is that it is a work in progress. And then there's additional discussion between Mr. Culhane responding to a Mr. Williams stating that the typical rock and roll band shows 105 decibels. which is from industry standards. Theoretically, it could go above that, but when going above 100, it becomes uncomfortable. Participants begin to feel discomfort not only in their ears, but physically. Very few concerts should exceed that over a period of time because it isn't healthy over a 2 or 3 hour concert. I suppose we might try to tell that to the tons of teenage and 20-year-old kids that pack. In fact, I think I went to AC/DC at Ford Field a year ago. I'm confident they were over that number, at least from where I was sitting, over the course of their concert. And thus, I wore hearing protection, so I could actually hear my next day's worth of motions. Just like this, I wouldn't be completely deafened by it. So, and then there's some. Mr. Fruit talks about those rock concerts sometimes being to 120 to 129 decibels there again, and which Mr. Williams again discusses. So, and then Van Strine clarified that while that may be the case, what they are be approving is a more limited level, i.e., there are some limits being envisioned for the this amphitheater. And the key question then, and then there's discussion about, well, Ms. Turkelson related that Environmental Services Division enforces the noise ordinance, and the city has a sound engineer consultant that can help provide technical analysis of the sound from various uses. And it talks about decibel readers and things of that nature, and whether or not there would be a violation of the special land use or noise ordinance. There's a direct question here. Ms. Joseph asked if the new noise ordinance will list specific decibel rates related to this type of venue, and Ms. Turkelson says that has not been determined. As of yet, that would be a code of ordinance under the authority of the city commission, presumably relating there to the actual noise ordinance. Surely she couldn't have been thinking at that point that the city commission would simply exempt the amphitheater from any regulation of its noise, but rather that perhaps there would be some adjustments or tweaks or modifications to the noise ordinance to allow for the operation of the amphitheater, because I don't think anyone ever had any doubt that there would be extra noise above the ambient street level noise generated by the amphitheater. As I said earlier, this isn't the harpist in the lobby of the Grand Hotel or the pianist that plays at dinner there, who conveniently probably limits the radius of their noise to exact size of the dining room or the lobby area, but rather these are performances where the audience expects them to be loud and projected throughout the audience, and it's further an outdoor performance, and ergo, I think everyone is operating under the correct assumption that this is going to add some level of noise to the environment surrounding, and the question then becomes, well, was that done during this meeting? And of course, that's the key question here as to the plaintiff's request for a declaratory judgment on their first count, and that is to enforce a statement that is made by the Mr. Culhane, who again is at least he is brought out here as the authority on this project. He is the manager and the one brought in to explain this sort of technical detail to the Planning Commission, which is being asked to pass the special land use here. And I think the key of Mr. Culhane's testimony, at least as I see it here, as I read it, begins on page 10 of that series of notes that make up this Planning Commission resolution. Mr. Culhane acknowledged that there were some concerns about rotating the amphitheater to the north, what the sound will do. They hired a firm to perform an acoustical analysis. They put together a virtual model of the architecture of the amphitheater as well as the topography and surrounding architecture of the area and did a 48-hour baseline sound study. The low end of the sound in that area is approximately 48 decibels and the high end is 73 decibels, which is an average reading 66 decibels in the area. And Mr. Culhane identified the location of the sound mixing board station. They took the stage house and created a 100 decibel sound source based on musical performance. I will note that that's somewhat below what the loudest rock bands were, but nonetheless, at a significant projection level. And then they measured sound level at the mixing board itself and took sound levels at various points. And Mr. Culhane described the environment relating to the lawn seating goes up 40 feet above the stage with a security fence and landscaping at the back of the lawn area seating, and displayed a graphic displaying the higher decibel readings, which are contained within the berm. And presumably there being the 100 decibel noise that, verges on discomfort. Some levels that reach in, there are some levels that reach into the 72 to 77 decibel reading, which is similar to the sound of a hair dryer or shop vac. Outside of the venue, the decibel readings drop significantly into the 62 to 72 decibel range. And then when you reach the expressway, there's a real change in the decibel readings. The expressway acts as a buffer. The only thing that really mitigates or stops the lower frequency sound is mass. They're fortunate to have the mass of the berm and the mass of the expressway, which do a nice job of mitigating the overall sound levels. Leaving the amphitheater property north of the expressway or even across Market Avenue, the decibel levels are into the green levels, which are unhelpfully not defined by Mr. Culhane here. Now, Mr. Culhane does respond to an inquiry here during these same discussions from Mr. Fruit. Mr. Fruit is misidentified. This is at page 15, and that's at the very start of the public hearing and public comment portion of this discussion. And Mr. Fruit, everyone agrees he's identified as Halford. Perhaps a pen name, but in any case, we all agree it's Mr. Fruit. Resident of Plaza Towers stated that he's in favor of the project overall. However, in the Grand Rapids Press article, it talks about how the venue was rotated 180 degrees to face north. Doing so was designed to project more sound towards downtown, where less residential housing is. There could be an asterisk there saying, of course, with the exception of the Plaza Towers and adjacent condominium structures. But here, I think everyone agrees it's a straight shot to Plaza Towers from the stage. It may, in fact, be the largest number of residents impacted by this. And Mr. Fruit points out that this isn't true because he himself lives there. And further, there are going to be some more residential units that have been proposed for construction in the old Charlie's Crab area and Amway parking lot. And then also goes on to discuss Plaza Towers, where he lives, JW Marriott, which is a hotel, not a condo, the Amway Grand Plaza, and then Bridgewater as the sound moves north. And then it goes on to note there was to be a 3D rendering of the sound provided, which has not yet been provided. With respect to the berm, the amphitheater is 2 feet above the S-curve. How the S-curve will block sound is questionable when the amphitheater is above it. Transportation and drop-off is also a concern. And then we go into some discussion about, transportation. And then we move to page 16, at which it says Mr. Van Strijn closed the public hearing. I don't think that necessarily bears on what we're discussing today, but Mr. Culhane apologized to Mr. Halford, aka Mr. Fruit, that he did not tell him he would, that he did tell him he would provide that 3D analysis of the sound prior to today. They met on June 8th and talked about sound. Mr. Culhane noted that some of the buildings identified by Mr. Helford are between a half and 1 mile away from this venue. The sound attenuation is going to drop significantly to levels of less than 45 decibels, which is soft speech. And I will note, everyone seems to agree that the ambient noise downtown is somewhere in the, or at least in the vicinity of the amphitheater, and also perhaps outside the Plaza Towers, somewhere in the 40 decibel to 44 decibel range on a daily basis due to traffic, street noise, etc. There is where that number of 45 decibels comes from. However, it is manifestly unclear as to what Mr. Culhane's talking about, if he's referring to he does say the buildings identified by Mr. Halford as being a half and 1 mile away. Well, I'm not exactly certain how far the Plaza Towers are. It appears that he's talking about at least some buildings that are further away, and of course it stands to reason that the furthest away building here, perhaps Bridgewater Place, in all the buildings discussed there from the amphitheater, might experience the most sound drop off by the time sound makes its all the way up to Bridgewater, perhaps some of it being absorbed by Plaza Towers and the hotels betwixt and between, because Mr. Culhane does say very clearly the only way you're going to stop these low range noises, bass type noises, is with a mass. And it is noted that, and in fact, Mr. Culhane does say that down here on that same page 16, lower frequencies tend to travel further, which is where you get the bass and vibration. The only thing that stops lower frequency is mass, and that there's this big massive hill, 200 dump drops a day for 100 days, that'll be creating the berm, and that it will absorb a significant amount of the sound. He goes on to discuss that 100 decibel reading at the mixing board, which may be greater than 100 decibels at the stage area. And again, discuss again about traffic and distraction of drivers and things like that. So there's a huge amount of discussion about the sound. And what does that tell the court? Well, sound was on residents' minds, notably here represented by Mr. Fruit. It was on the planners' minds. However, none of them committed to doing anything more than continuing the sound study and perhaps coming up with the promised 3D modeling of sound down the road. As counsel for plaintiff has pointed out, that doesn't appear that it was ever done. And all that ever makes its way into the discussion is this paragraph 6 in the resolution that the applicant here, the Convention Arena Authority, by this point continues to work with the city to evaluate potential sound noise resulting from the use and implement mitigation measures. So the finding of the court is that the special land use did not set a specific decibel level for this project, either at the project itself or away from the project at other points throughout. Now, in subsequent work, the city commission gets involved and modifies the city noise ordinance, and that is codified, hopefully without butchering the city's codification scheme here, under Article 5 noise control in the Grand Rapids, Michigan Code of Ordinances. That is attached to the plaintiff's brief as exhibit number 15, or at least part of exhibit number 15. It does have other provisions of the Grand Rapids Code in there. And in there, there are, of course, our definitions. Notably, there is no definition contained in this for prohibited noise. However, there is a whole section in the noise ordinance discussing prohibited noise. Several sections certainly could be applicable here, to the amphitheater, and notably, that would be subsection 1, limiting may cause to be made any sound by any means that creates a noise disturbance. Public assembly are exempted from operation of this subsection, in that perhaps again a public assembly utilizing a loudspeaker, something like that, although certainly I'm not saying that that is totally unregulated at this time. However, it has to balance with our need to provide expression, speech, and assembly for our citizens as well. There is another subsection here, and well, and certainly subsection 2. Now, subsection 2 does prohibit amplified sound between 10 p.m. and 7 a.m. However, that wouldn't per se cut out the amphitheater. After all, the amphitheater envisions having most of its performances between 7 a.m. and 10 or 11 p.m. At night. The Number 3 says allow real property under one's possession or control to be used for a residential disturbance. Not exactly sure if that's the one that fits here. And then number 4 says operate any device creating amplified sound on any public property or public right-of-way that is louder than average conversational level at a distance of 100 feet or more, measured vertically or horizontally from the source. That might allow that via, the harp in the Grand Hotel lobby. I think I could converse within 100 feet of that, but that would be about the max. And presumably those are our street musicians and people who play non-amplified music on the street corners all fit within those things. There are other prohibitions in that noise ordinance that apply, to a lot of things here. In subsection 8, lawnmowers, yard maintenance equipment, or domestic power tools, and in subsection 9, yell, cry, shout, whistle, or sing on a public way, so as to be distinctly and loudly audible. Again, however, certainly it would be arguable. And then 9.64 also talks about, again, some prohibited entertainment or commercial sound here, which isn't labeled prohibited noise, but is, perhaps more specifically tailored to this entertainment function that we're talking about here. And here, it limits that both with regard to time, nighttime hours, and sound includes all amplified and unamplified sound coming from an entertainment or commercial business, regardless of source, and indicates that would prohibit sound, noise that would be clearly audible, and this is subsection 3 of 9.64, noise in an outdoor area under the control of the establishment that would be clearly audible to a person of normal hearing located 100 feet or more from the property line during nighttime hours. Again, putting some time provisions on that. Notably, section 9.65 goes into a much more technical discussion of sound pressure limitations. And it does talk about, in subsection 2, special land uses. Now, it does qualify them that they're within SD-IT industrial transportation districts, and talks about residential commercial zone districts and distances. none of those being, on the record today exactly how this relates to the amphitheater. However, of note, what it does do here is it sets very clear ordinance-based decibel limits for sound, depending on, the octave band center frequency or hertz. Again, I'm wishing I'd paid a little more attention in physics, and then establishes some maximum sound pressure levels. And it says along district boundaries, daytime steady noise, residential, commercial, and then uh, does have repetitive impulse noise limitations that are 10 decibels lower. And then later in that same ordinance discusses what you should do at nighttime. And let's find out where that is. That's in a paragraph underneath the tables. For purposes of this subsection, maximum nighttime sound pressure between 10 p.m. and 7 a.m., 7 decibels lower than the value shown for daytime steady noise for each octave band center frequency. That's a very technical discussion of exactly what the city ordinance allows in terms of sound pressure. It isn't a discussion of prohibited noises, and in fact, the presumption here is that none of those would be, as long as you comply with sound pressure limitations, and you don't violate another prohibited noise category or time, that you would be within those. So that does provide some solid guidance that I think is worth noting here. And the court has to assume, as with all statutory interpretation, that when the city commission passes such things, they know what they're doing. They're aware of their surroundings, how the city operates. There are other statutory pronouncements that they've made. And that's why we give such great deference to legislative bodies passing rules like this and ordinances, is because the court doesn't presume to tread into that territory and set such limits itself. And that's why I'm very hesitant to extract that out of the special land use discussion, is because in effect what I'd be doing is extracting out a portion of that discussion and ignoring other portions of it when I can't make any crystal clear sense of what's being said during that discussion, other than there's quite a bit of ambiguity there. Whereas the ordinance, on the other hand, provides an unambiguous rule that appears to be followed. Now, section 9.66, immediately following, and notably, at least this was amended, if not, enacted entirely, following the planning for the construction of the amphitheater. In that subsection 6 of that section says sounds and vibrations produced at the Grand Rapids Kent County Convention / Arena Authority Amphitheater between the hours of 7 a.m. and 11 p.m. Except as provided in some section 7. And what it is, it says at the beginning here, the following uses and activities are not prohibited noises, i.e. they're not prohibited under 9.63 or presumably under the prohibited entertainment sounds addressed in 9.64. And 7 of that subsection 9.66 states that sounds and vibrations produced at the Grand Rapids Kent County Convention Area Authority Amphitheater after 11 p.m. or in the case of performance delays occasioned by unforeseeable exigent circumstances, including but not limited to inclement weather, that prevents the safe operations in the amphitheater with the prior written approval of the city manager or the city manager's designee, and does again create an exemption there for amphitheater performances that may go beyond 11 p.m. So again, the city commission here speaking, being quite clear about some very well-defined parameters time-wise for noise that comes from the amphitheater. However, none of this says that, by the way, this means we're abandoning these 9.65 sound pressure limitations rules in 9.65. I don't think that it's inconsistent with that. Certainly consistent that one could envision a situation where the amphitheater is constructed and the city decides it's going to enforce its noise ordinance as written in 9.65. And, in that ongoing discussion that's conducted primarily by the Planning Commission under the auspices of the special land use, come to the conclusion that, those are the numbers we're going to enforce. And those are the numbers that are in place. So I will find and grant declaratory judgment that section 9.65 of the city ordinance remains in force despite the exceptions created in 9.66. They just simply don't explicitly apply to 9.65. And, it would be also, we try to construe ordinances and things of that nature in a way that makes sense. It would be nonsensical to think that the city, acting through its ordinances or its special land use authority, would create a situation where there essentially would be no regulation or limited regulation of um, a noise producing use such as the amphitheater. Certainly, if the amphitheater became the, death metal venue for the Midwest and 7 days a week, played that loud and, probably to most people, I have a son-in-law that plays in such a Christian death metal band of all things, but I can't say I like the music very well, and that wouldn't create some problems, particularly if it was always at the what everyone agrees, or at least the University of Michigan thinks is the highest decibel level, somewhere around 120 decibels coming from the amphitheater. And I think there are a lot of fact questions that are left unresolved in that discussion. Everyone agrees that berm comes up to a certain level, but it doesn't appear that anyone, until perhaps later when they're doing those overlays later with that acoustic study, does too much thinking about, gee, what about the things that are located higher than the berm? Notably here, all of the plaintiffs' residents in the Plaza Towers are on higher floors. They're 16 to 32nd floors, hundreds of feet above the ground, and perhaps hundreds of feet above the berm, and there doesn't appear to be very much analysis of what's going to be the impact on those residences, when the sound travels, as it will, and some of it is going to be absorbed, but the only mass I can see when I look at the photos from the center mass of the amphitheater stage is indeed the mass created by the Plaza Towers. So I think that portion of the ordinance remains in place and enforceable. I will grant declaratory judgment at this time that portion remains enforceable. Now, what about the nuisance claim? Well, there is an argument advanced here that this ordinance violation can create a nuisance per se, and a secondary argument advanced at this time. And I will note that these arguments on nuisance are advanced primarily against the Convention Arena Authority. After all, the city did its thing, participated in this planning process, modified its, made its ruling on special land use, which essentially was, we're going to study this some more, and, modified its ordinance, and then transferred this piece of property, lock, stock, and barrel, to the Convention Arena Authority. So it makes sense that insofar that, the city is just simply not a proper party any longer on the actions against for nuisance. The city's not creating the nuisance. The city's is in charge of enforcing its ordinances, but after all, it's not creating the nuisance. If there is a nuisance created, it is by performances that are brought in and controlled by the Convention and Arena Authority. So I think that the city's motion for summary disposition as to the nuisance per se claim should be granted at this time. However, I do think that there is a question of fact on the question of nuisance per se and or nuisance in fact / public nuisance against the Convention Arena Authority that needs more discovery, because I haven't seen evidence. I certainly have seen suggestions, perhaps in the evidence presented to the court, that the decibel levels were projected perhaps to exceed the charts provided at 9.65, but I haven't seen any admissible evidence before the court that that's been indeed the case at these most recent performances. And I hesitate to even attempt to, speculate as to whether or not that's the case. So I do think that case can go forward because there is a question of fact as to both types of nuisance, but only against the Convention Arena Authority, the city having transferred the property at issue to the CAA, so that I just don't think they're a proper party any longer to the suit. Now, who wants to take a crack? I've denied in part, granted in part, and the order. Who wants to take a crack at writing something up here? I'll give it, since you went last in argument, Mr. Vanderveen, you want the first shot at this thing? Oh, did I lose Mr. Vanderveen? I hope not.
Ron, you're muted.
Nope.
Oh,
I
okay.
had it on mute. Sorry.
Good.
I
No,
said
I'm glad. Yeah, I was
be
worried I
glad.
was going to have to repeat myself. I can't even remember half of what I said because I was so long-winded.
I'd be glad to take a shot at putting an order together. I'll circulate it to council to review.
Very good. And I realize I covered a lot of ground here. So there's a lot to digest in the order. Anything I can clarify before we go back, Mr. Sweeney?
Yes, Your Honor. So I understand the court's ruling that summary disposition is granted as to count one. That claim is dismissed. The court has granted the relief requested in count two through a declaratory judgment. I am unclear as to count three. What the court said was that you believe that there's a question of fact as to whether there is a nuisance, and you need to see some evidence about that. But that is that's not what's pleaded. There isn't a nuisance claim. So what I would posit is, if the plaintiffs want to bring a nuisance claim, the court could grant them leave to do so. But count three is another declaratory judgment action that is asking for a ruling that a violation of section 9.65 would be a nuisance per se. I don't think the court has ruled on that, the motion to dismiss that count, and there could not be any factual development on that count because it doesn't allege a nuisance. So again, if we want some factual development here, the court would have to grant leave to amend to bring a nuisance claim. And I think the court still has to rule on what the relief requested in count three, which is declare that a violation of section 9.65 is a nuisance per se, because that's the relief requested. And that's why we argued that that count has to be denied, because there's no statutory authority that would allow the city to declare a violation of a noise ordinance to be a nuisance per se. The violation of the ordinance could only be a public or a private nuisance in fact.
All right. And Mr. Vanderveen, I know we're veering back into some legal arguments that I probably wasn't perfectly clear about. What are your thoughts on that is correct in that I think all three counts here we're asking for initially declaratory judgment. Clearly, I don't think I'm at a position to grant a declaratory judgment on count three yet on the nuisance per se claim. Where do you want to go with that?
Well, I think given the court's decision here and opinion here today, indicating the questions of fact to be resolved with respect to nuisance per se or nuisance in fact, that we, excuse me, that we should be given leave to amend the complaint. and to restate the claim there.
Yeah, I think that is, and you know, I am as much at fault for being unclear about that. So what I will do is I will deny declaratory judgment at this time that the violation is a nuisance per se. However, I will allow under the court rules time to amend the complaint to allege both nuisance per se, nuisance. In fact, I'll allow you to decide what you're going to include in the pleadings. I am unfamiliar enough with that underlying case law to know, you know, if or not Mr. Sweeney's argument there that, you know, there isn't any colorable per se claim here. If you wish to allege a per se claim, you know, in the nuisance action going forward, you can do so, and then we can deal with that in further motion practice.
Okay, so just for purposes of preserving the record, Your Honor, are you denying my motion as to count 3 without prejudice? In other words, like if he brings a nuisance per se claim, I could then reassert the same argument that there can't be a nuisance per se for this ordinance violation.
Yes, I think that's accurate.
Okay.
So we've got a deny, grant, and a deny without prejudice with leave to amend. How long are you going to need to amend that, Mr. Vanderveen?
2 weeks would probably be a good time.
Okay, why don't we set then plaintiff to submit amended complaint within 14 days of the date of the order.
Sounds good.
Very good. Thank you all. This is complicated and not very frequently trod ground, at least for me in the circuit court, but your briefs are all well enough written that I understand a lot more about the process now than I did at the outset. Hopefully I gave you some clarity going forward. I appreciate all the hard work so far.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.